Hi friends, I am Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, earlier I have made a similar kind of video in Hindi language, but as per the request of many of the viewers and subscribers, they asked me to make a video in English how to obtain bail under section 138 of the Negotiable Instrument Act if a check is being dishonored, and offence committed under section 138 of the Negotiable Instrument Act, and the complainant file a complaint and the magistrate take cognizance, then what is the procedure to obtain the bail? Will you get the bail? Will the drawer of the check get the bail, or he is first required to go into the imprisonment and then he has to obtain the bail? This question always arises when the drawer issues a check and that has been dishonored. So first I would like to ask that if you have not subscribed my channel, please subscribe my channel, and if you like my videos, please like and share my videos. Friends, there are two types of offenses, bailable offense and non-bailable offense. Fortunately, offense under section 138 of the Negotiable Instrument Act is a bailable offense. So in bailable offense, bail is your right. You will definitely get the bail if you abide by terms and conditions of the court and fulfill all the documents and present bail and bond documents as per the orders of the court. So you need not to worry. What is the bailable offense and how you got the bail? Section 436 Cr.P.C says that in a bailable offense, bail is your right. I would like to read section 436 of the Code of Criminal Procedure. In what cases bail to be taken? When any person other than a person accused of a non-bailable offense is arrested or detained without warrant by an officer in charge of a police station, or appears or is brought before a court and is prepared at any time while in the custody of such officer or at any stage of the proceedings before such court to give bail, such person shall be released on bail. The word shall has been used, meaning thereby that the court shall release the person on the bail. The court cannot refuse to grant the bail, but the person, the accused, has to fulfill the orders of the court. He has to file bail and bond documents. And if the court asks for surety, one surety has to be present, one or two surety has to be present before the court and gives bail bonds. Now the question arises, what is the procedure? When the complaint filed under section 138 of the Negotiable Instrument Act and the magistrate take cognizance, the magistrate first used to issue summons as against the accused. When a police officer came along with a copy of the summon, you need not to worry. Take a copy of the summon. If the police officer asks to execute a bond, execute a bond. Appear on the date mentioned in the summon before the magistrate court and obtain the bail. If you do not appear even after obtaining the summon, then the police officer will report and the court will issue bailable warrants. These are the sequences: summons, bailable warrants and non-bailable warrants. If court issue bailable warrant and the police officer came along with the bailable warrant, you will not be arrested. Please mind, you will not be arrested even in the case of bailable warrant. What you have to do, you have to execute a personal bond before the police officer and note down that what is the next date of hearing and which court has issued the bailable warrant. Then you have to appear before the honorable court and execute the bail and bond as per the directions of the court. But in case you even not appear in the bailable warrant, then and then only the magistrate will be bound to issue non-bailable warrant, and in that case the police officer can arrest and produce you before the honorable court which has issued the arrest warrant. So you just avoid that condition and appear as soon as you got the knowledge that summons has been issued or as soon as you receive the bailable warrants and obtain the bail before the honorable court. Now question arises, how to draft the bail application and how to obtain the bail. Appear through a lawyer before the court which has issued summons or bailable warrant or arrest warrant in section 138 of the Negotiable Instrument Act on the date which has been fixed by the court in case of summons and bailable warrant, and in case of arrest warrant you have to appear at the earliest. Then You have to draft a bail application of formal nature under section 436 of the Code of Criminal Procedure. How to draft? Just mention the name of the court, title of the case, then mention bail application and offence punishable under section 138 of the Negotiable Instrument Act. Then start drafting that your lordship, this is a bailable offence. The accused is ready to furnish bail and bond as per the directions of the court. The accused is resident of India and there is no likelihood to run away. The accused will abide by all the terms and conditions of the bail and bond as per the directions of the court and will appear on each and every date of hearing as per the directions of the court. Then mention the relief clause that accept the bail and bonds and kindly enlarge the accused on the bail. Then after ensuring all the documents, and the magistrate court will surely enlarge the accused on bail because it is his right. Then question arises, what documents is required to present along with the bail applications? So personal identification of the documents of the accused, personal identification documents of the surety, then photographs of accused and photographs of surety is also required, and some surety documents like property documents, vehicle documents, any valuable security documents, FDR documents. But remember one thing, that you have to only show the original documents and submit the attested copies. You do not require to submit the original documents before the court. Now, we would like to discuss two important judgments in this respect delivered for section 138 of the Negotiable Instrument Act. Honorable Rajasthan High Court has delivered one important judgment on 10th of January 2019. The citation is Sona Goyal versus SVipul Nagpal. What has been held in this judgment by the Honorable Rajasthan High Court? The Honorable Rajasthan High Court held that bail is a right under section 138 of the Negotiable Instrument Act and it is a bailable offence. Number 2. In case surety cannot be arranged by the accused within a period of 1 week as per the mandate of section 436(1) of the Cr.P.C, the magistrate is bound to release the accused on bond executed by him, on the personal bond. What does it mean? That if a magistrate orders that kindly arrange surety and the accused cannot arrange the surety within 7 days, even then the magistrate is bound to enlarge the accused on personal bond. And the third is that magistrate cannot impose a condition to deposit passport while granting the bail. This is a very important aspect, that magistrate cannot impose such condition to deposit first the passport, then and then he will only grant the bail. Then Madras High Court has also delivered one very important judgment. The title is Reghupati versus Govindan and another. It is delivered on 15th of March 2006 and that has also been reported in the Criminal Law Journal 2006 page number 4232. What has been held by the Honorable Madras High Court? It has been held that if a magistrate issue directly non-bailable warrant without issuing a bailable warrant, then the accused is having a right to grant anticipatory bail under a petition moved before the Honorable High Court under section 482 of the Code of Criminal Procedure. So today we have discussed that how to obtain the bail if an offence under section 138 of the Negotiable Instrument Act has been committed. Thank you friends. Hope you like this video. Thank you so much.